We're on the YouTube.
All righty, welcome everybody to House Energy and Digital Infrastructure. Today is Thursday, April 10th, and we are here with Ellen Chakowski from Ledge Council to walk through H394, which is an act relating to renewable energy generation. This is adjacent to our work on S50. I felt like it was important for us to understand the whole bill. And then in particular, we've been taking testimony around Section 3, which is around single plane. So, and then after we finish that, I guess we could just move into our discussion of S50. We have an updated draft, which is amazing. And we are also talking about single plant stuff. So I think I've encapsulated everything we're doing. So we'll go around the room, introduce ourselves, including folks who are visiting, and then we'll turn it over to you. So I'm Representative Kathleen James from the Bennington 4 District.
Scott Campbell from St. Johnsbury.
Richard Bailey, Lamoille 2. Chris Morrow in the Windsor, Bennington. Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Darren Torrey, Washington 2.
Graham Clifton, Chittenden 13, Burlington.
Jack Locker,
Committee Assistant. Thank you.
Peter Sterling, Renewable Energy Vermont. Dylan Zwicky, and Public Affairs for GMP.
Oh, I didn't even see you over there. Sorry, Dylan.
And that's always an intern.
Great for
Representative Lisa Hango.
Hango. Okay,
Greg Faber, work with PDC.
great. All right. Ellen.
Ellen Chakowski, Office of Legislative Counsel. So I'm here today on H394 as introduced. I do think you heard from Representative Sheldon a few weeks ago on her position as the sponsor, but I don't think we've done a walkthrough at all. So this is a collection of different provisions related to renewable energy. So it's kind of a miscellaneous bill. The first section is amending 24 VSA 4352, which is the optional determination of energy compliance, but also known as the enhanced energy planning. And so I don't think we've talked about this too much, but generally speaking, both regional planning commissions and municipalities have the option to go through this optional enhanced energy planning process. And this bill is proposing to add an additional requirement to that process. There are a few steps that they have to do to obtain the enhanced energy designation, and that gets them the substantial deference as part of PUC hearings on energy generation applications. So it's adding to the list of things a plan must, and then all the way down at the bottom of page 2, the plan must be consistent with the following, and it includes references to Vermont greenhouse gas goals being changed to reductions, and then Vermont's other goals, the 25 by 25 goal, the building energy efficiency goal, and the state energy policy, and the tier 2 and tier 3 requirements, and it's adding reference to Vermont conservation design. And so I think you all heard about that recently. Did you have a hearing on Vermont conservation design?
We did.
Yes.
So Ellen, this is existing statute that explains what folks have to do to, I guess, achieve this substantial deference, what towns have to do.
Yep.
And it updates goals to requirements to bring it into compliance with the GWSA, and then it adds Vermont conservation design.
Mm-hmm.
Okay.
So we're specifically talking about towns now.
So both towns and regional planning commissions can go through this process. Yep. So it's both
Can go through, but aren't
required. You know, it's, the whole thing is optional. Yep.
And if a municipality or an RPC chooses to go through this process, then they receive substantial deference at the PUC. So it's an advantage.
Yes.
Basically, it tilts the scale more in favor of what the town or the RPC is choosing to do in terms of its energy siting.
Yes.
optional process. You can do to win points. Okay. Free?
Yes. Section 2 is amending 30 VSA 8010, which is the net metering rule statute that you all have been looking at recently. And so it's adding language on page 3. The rules shall establish, so starting on line 10, the rules shall establish and maintain a net metering program that. It's adding language in subsection B that achieves a level of deployment of no less than 20 megawatts per year and is consistent with the recommendations of the electrical energy comprehensive energy plans, unless the commission determines that this level is inconsistent with the goals. So it's adding a specific target for how much net metering should be deployed each year, 20 megawatts per year.
Questions about that? For now,
We're just going through. What
394.
it says, not why, right?
Well, thoughts on why? Why is more Amy Sheldon probably than, but
Yeah, I don't have the specific answer to that, although I suspect it. Actually, no, I don't know why that specific number was chosen.
okay.
On page 4, there's the same change that you all have been looking at in S50, changing 15 to 25 kilowatts. And then section 3 is the single plant language that you have been hearing about. So section 3 amends 30 VSA 8002-18. So 8002 is the definition section for the renewable energy chapter 89. So that applies to the renewable energy standard and the programs associated with that. So that does include, as you've heard, standard offer and the net metering programs. But I would also just like to add, because I think it came up but hasn't been said specifically, this definition is also used as part of, it's in section 248. It's referenced a few times there as well. Generally, it's referring to energy generation facilities, but it does also reference plant a few times. So this definition does have use in other parts of the statutes on energy generation as well. So plant means an independent technical facility that generates electricity from renewable energy. The proposal is then to strike the rest of the existing definition and add new language, which appears on page 5. So the new language would be independent technical facilities that are co-located on the same parcel shall not be considered a single plant if each facility uses separate generators, inverters, and production meters as applicable, and each facility has a separate interconnection point to the electric grid. An interconnection point is the point at which the interconnection between the interconnecting utilities electric system and the renewable energy plant's equipment interface occurs. Utility-owned electric distribution and transmission lines shall not be considered part of a plant or interconnection point. For purposes of eligibility in the net metering program under 8010 of this chapter, co-located independent technical facilities may not exceed a cumulative total of 500 kilowatts in nameplate capacity. I do not understand a lot of the technology that's being discussed here. This is a little more technical than the existing definition. I did want to flag for you that this definition of plant has been litigated multiple times and may be the subject of litigation currently. So this is an issue that has come up before and has come up in previous legislative sessions because of some of the reasons you've heard. Whenever you set, a size limitation on things, there will be people seeking to figure out how to get around that kind of limitation. So there have been multiple cases. I haven't finished reviewing all of them, but there have been multiple court cases interpreting this definition. So you might want to hear about some of that litigation. I don't know how much time you have, but both the PUC and the department were involved in the litigation with the developers challenging the PUC's interpretation of this definition. The only other thing I would add is that the original definition that was added in statute had the first two sentences, and then the third sentence was added later during one of the net metering updates. And so I think that also probably came out of some of the issues that were coming up, and especially related to the net metering changes that were coming about at that time. So this is a working definition that has been used, and yeah.
Sorry,
Campbell?
you said the last sentence was added during the.
Yeah,
That mean question, the consideration.
Yeah, so the common ownership sense, the sense that says common ownership to the factors. I didn't know if you wanted me to read through.
The struck out part?
Yes, sorry, so,
Okay. I thought you
Yes.
were talking about the other part.
no. So all the stuff that's underlined is being proposed, but what's being
Yeah.
struck out is what is in the existing definition, which is 3 sentences.
Yeah.
And so it is something that the a legislature enacted and then changed as the programs were evolving. But that predates me. That was 2014 when that was added. So it was part of the net metering update.
Explain to us again, one more time, the upshot of how the language is now and what the new language implies for how things would change, right? So this is how it's worded now. This is how it works now. If we go with this new definition, this is what it means, and this is how it would work under the new definition.
I will try.
Okay,
So currently, under the definition, it's looking at a group of facilities. And so looking at what is a single plant. And so you look at if it's part of the same project and uses common equipment and infrastructure. And then it says roads, control facilities, connections to the grid. It also added some additional factors to consider: common ownership, contiguity in time of construction, and proximity to facilities to determine whether two facilities are part of the same facility. This is changing that to look at more the technology involved, I think, saying even if they're co-located on the same parcel, they're not going to be considered the same plant if they have separate generators, inverters, production meters, and separate connection points to the grid, interconnection points to the grid. I don't know. I think you may have had some testimony about this, but I don't know the technology aspect about how interconnection points work. There's some additional information here. But that's a level of actual technology I'm not familiar with, so I don't know the point at which separate interconnection points are required as opposed to optional. And then it does go on to say for the net metering program, co-located facilities, independent co-located facilities that may not exceed a cumulative capacity of 500 kilowatts, which is the cap on sizes for net metering projects. Right. So I think, this definition is getting away from looking at the factors that are currently in statute, which are same parcel and shared infrastructure, and looking more at if the technology itself is separate. I think, as you've heard, in an attempt to be able to share infrastructure.
okay. I think, why don't let's keep walking through the bill. And then, we have folks in the room. If we want to have more of a conversation about the single plant stuff, we've got folks here that could help us do that. We could just add their names to the agenda impromptu if people want to talk about it now. But let's finish walking through 394 and then come back. Basically, I don't think we have anything else on the agenda besides S50 until 11. Or are we doing this all morning?
Until 11, correct.
Okay, so let's finish task number 1, which is to walk through 394. That sound good?
Yeah.
Okay.
All right, so section 4 is amending 30 VSA section 248. It's adding language starting at the bottom of page 6. So with respect to a facility located in the state that is 5 megawatts or less, the commission shall issue a decision on the certificate of public good application within 12 months following the application being deemed complete. With respect to a facility located in the state that's greater than 5 megawatts, the commission shall issue a decision on the certificate of public good application within 15 months following the application being deemed complete. So, currently in statute, there isn't a deadline by which the PUC is required to issue a permit for electric generation facilities. So this is seeking to have a timeline for less than 5 megawatts, 12 months, for more than 5 megawatts, 15 months.
Questions, comments? Yeah, Victoria.
I feel like there was a recent report about timeliness and how long it takes to get things through the PUC, but, and maybe we should have it on our website. I don't know if I've read it. But I feel like is it inaccurate?
We should ask for.
Yeah.
It's called out.
Okay. And then on page 7, subsection B is a different topic, but still in section 248. The commission shall have no jurisdiction under this section to consider the actual or potential impacts caused by any electric distribution upgrades, except to assess impacts under subdivision B3 and the public health and safety impacts under B5 of this section. Party status and notice requirements related to distribution upgrades shall be consistent with the scope of the commission's jurisdiction described in this subsection, with the exception that affected electric utilities and the Department of Public Service. So this is limiting the PUC's review authority for electric distribution upgrades under 248. And so I don't have B3 in front of me, but B5 is public health and safety. And yeah, so it's limiting some of their review of these projects.
Aesthetics and
It might be aesthetics, yes.
B3 will not adversely affect system stability and reliability.
Oh, so, okay, so that does make sense, right? So they can still look at system stability and reliability and public health and safety.
But it would be anxious aesthetics.
Yeah, and the environmental criteria, yeah.
Wish list.
Mhm.
I said, that's a wish list.
Okay,
All right, section 5. Section 5 is creating a public energy advocate. So it's amending the section related to the Attorney General's authority. So first on the bottom of page 8-7, that's that's a technical correction, a stylistic, going from his or her to just the gender neutral noun of the Attorney General. And then on page 8, so subsection D is a new section that would be added, and it says the Attorney General shall appoint a public energy advocate who shall assist applicants in the process for receiving a certificate of public good under 30 VSA section 248. The public energy advocate shall advocate for the applicant and the public before the Public Utility Commission for the development of new energy storage and generation projects. Section 6 then technically creates that position and appropriates $120,000 from the general fund to the Office of the Attorney General. So currently, the Department of Public Service has the Public Advocacy Office, And they go before the PUC in its proceedings and act on behalf of ratepayers and the public more generally. This is a little bit different, and the sponsor is seeking to not house it at the Department of Public Service so that it could be a different independent voice assisting applicants, almost like a public defender would. So assisting people with the energy process. Yeah.
Rep. Sibilia?
See more.
Others
Really getting.
apparently Massachusetts has done something like this. It is.
What's the problem it solves?
I think I kind of am thinking of it like a public defender in that separate from the department who may be, it's hard to read because this isn't I'm not the sponsor of this bill, but I think it's to have a different, more independent advocate assisting applicants before the PUC, as opposed to the Department of Public Service, who advocates potentially more for the public at whole, but is also an executive branch agent, part of the executive branch.
So this one would be intending maybe more towards advocating for more renewables as opposed to advocating for lower rates.
Maybe, but also individual applicants.
Yeah, my sense is it's more like the healthcare advocate, someone that a Vermonter can call up and say, man, I'm so tangled up in the PUC, I can't get my project through. Can you help me? Well, that sense of this intention.
Okay.
And then finally, section 7 is a report. So energy projects and forest blocks. On or before December 15th, 2025, the Public Utility Commission shall report to the House Committees on Energy and Digital Infrastructure and on Environment and the Senate Committee on Natural Resources and Energy on how much forest land has been converted for renewable energy generation facilities and what types of mitigation, if any, were implemented for those projects. So this is asking the PUC to look back if they have any data. Hopefully they have some data, but if they have any data on what kind of mitigation they've required for logging, required for renewable energy generation. The PUC has some authority to require mitigation when there are environmental impacts. And so I think I've heard of some projects, but Representative Sheldon is very interested in deforestation and land use changes. And so this is of interest to her to see how much forest land conversion there has been and if the PUC has been requiring mitigation for that.
Okay. Great. That's the bill?
That's the bill.
Okay. So read that 394.
Yeah, I cannot say I understand the crucial part of this, which is section 3. I'm not going to do that now or later, but the single plant scale stuff is still a little confusing to me.
Thank you for joining me. So my first baseline question is on 394. Does anybody here on our team feel a burning desire to dive into any other section of 394 right now, this session, and pull it into S50? I do not.
I'm still a little curious about
So besides single plant, like we're deep into that conversation.
the 20 megawatt per year target or goal. Achieving a level, it's in section 2. Achieving a level of deployment of less than 20 megawatt per year. Why did we say that? Does it have to do with the rising tier requirements? That's tier 1.
Tier 2 is rising. At
Yeah,
the-
tier two.
Yeah,
partners.
and this is the net metering statute. Which,
Yeah, so maybe it's an effort to uh, meet that target, right target. So, not probably looking for answer, but-
The question is,
Hearing none, yeah, I mean, I wanted to walk through the whole bill and make sure that we weren't overlooking a piece that anybody really wanted to dive into to try to attach to S50. We're already having a, extensive conversation around pulling out section 3 and attaching it to S50. I am not feeling a burning desire to dive into any other parts of it right now for S50, but happy to hear other thoughts.
Section 4 is interesting, but not for S50. I think it's something we need to spend more time on in terms of the timing of these things getting permitted in that process and what the jurisdiction of the things should be. That's not a S50.
Okay.
That's for the parking lot.
Well, and that's a great thing to point out. It doesn't mean, the whole bill's dead or something. It just means like we're doing S50 now. It's live. We're going to try to bring it to the floor soon. And then we have a whole list of things we can think about and do and be maybe more ready for next year, which could include taking tons of testimony this session yet, right? So it doesn't matter. It doesn't mean we're never doing it. It just means we've got one little thing. We've got one little train cart moving back to the Senate this year. One little Thomas Denny, whatever. Even myself. Yeah, Rep. Southworth.
I'm not feeling overly warm with it as we thought of that, to be honest.
Okay. So anybody else besides single plant, which now we're going to clearly really talk about, any other pieces of 394 feeling urgent to you?
no,
No, but I think the money issue kills it.
Okay.
single.
So no, hearing no's.
What's the question?
Anything else?
The question is there anything else in 394? Single plant, we're already talking about, we're discussing. Is there anything else here that's not single plant that anybody is like, we gotta get that into S50 right now, this year, put it in the cart so we can talk about it? Nope. Okay, Ellen, thanks. So 394 goes into the parking lot with the exception of single plant, which we've already been taking a ton of testimony. So we've got folks, Ellen has an updated amendment for us on all parts of S50 that we agreed on yesterday. I am feeling like we could even set that aside for right now. Here we are at single plant. We've got folks in the room. So, what do you think, guys? Should we dive into single plant? We need to decide whether to put single plant in as drafted, leave it behind for now or until next year, or see if there's a compromise version that folks can agree on. Okay, so next steps.
It seems to me where we left this was, PUC not wanting to consider it in general because of potential impact in that metering and standard offer. And renewable energy folks saying, well, let's pull out that metering and standard offer. And just consider it for basically new market rate power purchase agreement, just other things or generation facilities. But I think for myself, I feel like I need a little bit more grounding in that, so to speak.
Okay,
Speaking.
Rep. Sevilla and then Tori.
Yeah. I am in favor of us trying to locate more solar in areas, that we want it, concentrated. I very much appreciate, the caution from the PUC around, net metering and standard offer. And that we have gotten some, advice, from, advocates on how to potentially mitigate that. I think I am in the same place as Rick Campbell. I really want to understand, if we have, if we've kind of constrained the, if we were to make that adjustment to the language that was recommended to us, if that would kind of mitigate the financial impact. And so I think I might like to hear from the PUC about whether or not that would be helpful. More solar in places that it already exists. If we can do this in time, I think it makes sense. And if it's not, if there aren't any surprises financially.
Victoria?
Yeah, I would agree. I'd like to hear from the PUC on this proposal about the list.
Rob Kleppner?
One of the things that chatted with Bailey yesterday, having rules that require someone to build a new road next to a perfectly good one just to meet a bureaucratic requirement is the kind of thing that causes the public to tear their hair out about Montpelier and our work. And to the extent it feels to me that there is a relatively straightforward fix for that particular problem so that we stop wasting resources and money, which is ultimately ratepayer money, and also doing the environmental damage of running a second road where you don't need one, et cetera, et cetera. I think we have an opportunity to fix a problem that's costing people money, and the fix doesn't cost anyone anything. So I think we should screw up our courage and do it.
Ellen, I think that we can play musical chairs. So let's see, best order of operations. First of all, some folks have joined us. We always like to introduce everybody for the record. So Ben
Edgerly Walsh, with the Vermont Public Interest Research Group.
And my intern.
Hi, my name is Quinn. I'm an intern from BBA, with a success program principal.
Yeah, here for the day. All right. Good. So would you go
add to what Governor just said? So, if perhaps it's possible, if that is your concern about specifically the roads, you're getting, this proposal is to get rid of the rest of that language, including the road part. Perhaps you could try to just amend the current definition and say something such as shared roads shall not be dispositive.
Roads, but there are a few other things, utility poles and things like that. But I think using the separate inverters, separate interconnection points, like that stuff doesn't seem to be causing a problem. It's just the infrastructure pieces, the roads and the poles and so forth that feels like fix.
Any concerns, Ellen, about trying to make sure there are not unknown financial implications happening here? Or advice for us? Flags.
I broadly, this is giving me, it reminds me of in other permitting systems, when you set a definition that is the threshold, that dictates which process you go through, or perhaps which compensation you get. There will always be people, in my opinion, who are trying to avoid that definition in some way with creative layout. And so attempting to predict all of the outcomes can be difficult, because I do think people want to avoid legal processes as much as possible, which can be understandable. But would be interesting, given that there has been litigation over this, it's interesting to me, that it's been litigated before, and so it's being brought forward to, and in that litigation, and I haven't read through, there are multiple cases, but the PUC's decision has been upheld multiple times by the courts on their interpretation of the current definition. So, and then this would be changing the whole definition essentially.
So, but we changed prevent metering.
Yeah,
You don't think that that's next year?
I am not truly an expert in that space, but this definition does apply in other places as well. So I'm not sure.
Remind me where else it applies.
So it applies to the rest of the chapter, and it is also used in a few parts of section 248 as well. So I don't have a great suggestion on this because I'm also still digesting this proposal.
Rep. Safford?
Yeah, I agree about the road piece. I mean, having to build a new road in is ridiculous, especially if it's past there. But I would really want to hear some more on the litigation that has happened and see what the reasonings are for the litigation, what the decision was. I would love to see that because that may make us see something that we're not seeing at this point.
Okay. Let's see. How about, do Ben and Peter have some proposed compromise language that we should talk about, take a look at, and then hear from the PUC? I mean, are you guys okay with just joining us? You're here we all are.
And in the interest of time, Ben is perfectly capable. We don't need both of us. So
Is that okay, Greg? Okay, Jack, can you update the agenda? And just pop on there under our S50 discussion that we're hearing from Ben Edgerly Walsh from VPER, Peter Sterling from Rev, Greg Faber from the PUC, and Dylan nope.
Well, I'll keep the door open.
Pardon?
I'll keep the door open, but not at this time.
Okay.
Let the record show. Potential witness declined invitation.
No, just we don't like to spring it on people. So, alrighty. But Ellen, you can hang around, right?
Yeah.
Or do you need to
Oh,
go?
yeah, no, you booked me till 11.
Oh, right. Okay, great. Well,
Yes.
here we are. Super, Ben, for the record.
For the record, want to get on the chair first.
And start us again, just quickly, with how it works now, how it's defined in law now, why that's a problem, and what we're trying to fix. Just, you don't have to start at the beginning. Let's just level set here.
Yes, for the record, Ben Edgerly Walsh with the Vermont Public Interest Research Group. To be a little bit redundant but thorough, right now we have a situation where the definition of plant creates a situation that we've just been discussing where equipment and other infrastructure like roads, poles, wires, etc., that is not necessary from a technical or engineering standpoint for a plant to be built, winds up being required so that second, generally speaking, it would be an existing facility and then something else being built right next to it that is trying to be its own plant, its own facility, but benefit from some of the existing infrastructure. Can't do that they would need to build additional road. But to the point that you just made, Representative Klubner, it's not just roads, it's a lot of other infrastructure, and this can run into I don't have specific examples, but certainly the tens of thousands. I would imagine it's not difficult to imagine this being north of $100,000 in some instances, maybe significantly more than that, but I don't want to speculate beyond that. And so what I testified to yesterday was the idea of saying, for net metering and for the standard offer, don't change anything. Keep the existing definition that addresses, I believe, most of, perhaps not all of the concerns that you've heard from the PUC, and certainly speaks to the original rationale of this, which was created alongside the standard offer in 2009 to make sure you don't have developers building a larger project and slicing it up in artificial ways so as to benefit from programs intended for smaller projects. So to use one example, you couldn't have a developer saying, hey, I'm building a 2 megawatt solar farm, but really it's 4 500s. And can you please give me the same rate as you would give a single 500? That obviously is not what was intended by that metering statute. And so keeping the current definition for those two programs makes all the sense in the world. What I suggested was going with something like what is in 394 or the language you saw from Renewable Energy Vermont the other day, which was a slightly simplified version of that, with a total cumulative cap for a site of 10 megawatts for everything outside of net metering and the standard offer. And I worked with Renewable Energy Vermont, an attorney that they work closely with, to come up with potential language for that. I shared that with the chair, although only late last night, so I don't know if you had a chance to look at it. And I don't.
I did, and I didn't share it around because I wasn't sure if it was ready for, if you guys are ready to share it out. So do you want me to forward it? Or do you want to send us something?
I'm happy with your forwarding, of course, it's in your hands. Obviously your decision whether you want to run that through Ledge Council before your committee sees it. I will say I can certainly give you the broad strokes. I had not prepared this morning for doing a line by line walkthrough of the language.
Okay.
But that's
That's
to
fine.
do whatever you think is useful.
I think what might be most useful probably would be to just have a discussion now. Let's hear from you guys about what you're thinking. We can hear from the PUC about what they're thinking. And then maybe Ellen could come back with something tomorrow that we could at least look at and discuss. Does that sound good?
So that works for me.
Okay.
So let me just briefly touch on a couple of features of language, but not, well, you tell me whether you want to actually share the full language. My suggestion would be I can touch on the features of it, and then I can get out of the chair and you can hear from council tomorrow on what this would actually look like from that perspective. So one, it does include the cumulative size cap for a site of 10 megawatts. I will say, I don't think that's certainly not a magic number. That would be up to 2 of the 5 megawatt systems that would qualify for tier 2 of the renewable energy standard, 5 megawatts being the single plant cap for eligibility under that part of the renewable energy standard. Essentially, the 10 megawatts, as I understand it from Rev, is intended to put a reasonable limit so that you couldn't have a sort of infinite number of these things stacked next to each other. So it allowed for good land use, but avoid a conversation about exactly what is the sort of upper size that we would ever want, solar to be in Vermont. I'll also note that there have been one, or maybe Peter knows, 2 20 megawatt solar farms that are actually 20 megawatts in a single plant intended for operation as a merchant generator that can be sold in Vermont or anywhere in England. Those facilities of that size have already been built in Vermont. So a 10 megawatt cap for a single site would be half of the size of the largest solar farm built to date in the state.
So the 10 megawatt cumulative cap would be up for a single site
Yes.
as defined by the infrastructure, basically, like.
Yeah, essentially the goal of the language would be to say, if you're trying to build more than 10 megawatts, you don't get the benefit of this single plant definition. We can work on the language. Happy to talk to Ledge Council about the language, but that's the concept.
Okay.
I see it here.
I do too.
Good.
Rep. Wagner?
Gosh, she's good.
Yeah, because she is not looking at you.
And I should get that. She's a mother, so she can see 360 degrees.
All the way around the back of my
All the way
head.
around.
Go to your room.
Um,
Okay.
Sorry for the digression. Where are those two 20 meg solar facilities in Vermont? Do you know? Does anyone know?
Do you know, Peter?
Well, the ones that are, well, there's an existing one in near Ludlow. But there's one proposed, a big one's proposed up near Shaftesbury, and there's a big one being proposed up near Berry.
There's one near Ludlow.
There's an existing one that was built a long time ago.
I've spent a lot of time in that part of the state. I've never laid eyes on it.
It's near it's just southwest of Ludlow, where the town where Calvin Coolidge was born.
Cool.
Plymouth.
Plymouth.
Limits.
Near Plymouth,
Took me a minute.
right in there.
Oh, very good.
I was like, Plymouth. And then so you said the largest site, single site in Vermont right now is 20 megawatts. That's the one near Ludlow. And then the one that's being proposed near Shaftesbury. I think all of us who live in Bennington County are probably familiar with that. Or Southern Vermont, or maybe anywhere are familiar with that. Ongoing situation.
So are these large solar connected directly to Velco, or are they coming in through Green Mountain Power's sub transmission?
It's through Green Mountain Power subs.
All right,
I'm sorry, I have one more question.
to the single plan
If I'm
issue, yes.
Yeah, I'm just wondering about the 10 meg size. ISO prefers 5 meg and below for distributed generation. Is that accurate?
I don't know that they would characterize it as prefers. They have a definition of and a sort of a test for generators. If you're above 5 megawatts in size, then they have more sort of regulatory control over that facility's operation. And they have a test that says whether in this sort of instance where two facilities are very proximate, whether it would be considered one facility or you would have to group them and say, oh, now you're above 5 megawatts and this test gets stripped. It's similar, but I wouldn't say it's identical to what we're proposing.
Yeah, so they've got a way to deal with it. They won't freak out. Everyone's fine.
I don't want to characterize what ISO New England may or may not do. I will say that the state's renewable energy standard definition is in statute because of that 5 megawatt line for ISO, but isn't directly linked to it. So the definition of the renewable energy standard simply says a plant of 5 megawatts or less. And so that runs in parallel to ISO New England's 5 megawatt generator threshold, but it doesn't actually reference ISO New England in that definition, if that makes sense. So it's a definition in Vermont statute. Okay, so just to wrap up on the 10 megawatt, the way that we have thought about this, proposed this is, it wouldn't be barring more than 10 megawatts. It would simply be saying you get the definition of this, you get the benefit of this new definition up to 10 megawatts. If you try to go above that, like you just have to start building new infrastructure and you're back to the original sort of situation so there'd be an incentive to not go above that 10 megawatt, but not an absolute bar. Last couple of things I would say, and then I'll leave you to other witnesses. One, as I laid out earlier, just a few minutes ago and yesterday, the idea would be that the current definition will remain unchanged for net metering and standard offer, all net metering and standard offer now and in the future. And the new definition, which again, the goal would be to not require additional infrastructure that's otherwise unnecessary, would apply to everything else. Lastly, we included some language to clarify that the proposal or existence of a new facility outside of net metering and standard offer wouldn't impact the eligibility of a net metering or standard offer facility. So if hypothetically you had 150 kilowatt solar array that's enrolled in the net metering program, and that happened to be on a site where you somebody wanted to cite a 5 megawatt PPA. Now you have 5.15 megawatts all together. 150 is trying to be net metering, trying to still be net metering, and you've got a 5 megawatt being added to it. We would not want a situation in which that 150 kilowatt is then not allowed to be net metered because it has a single client definition that says, oh, you need to add that 5 megawatt to it because it's being co-located. So it essentially says there's no impact on the eligibility of net metering or standard offer if a non-net meter standard offer plant is built on the same process. So,
Yeah, sorry.
I'm feeling a need to provide some disclosure to the public and to my colleagues based on your comments that on family land, my brother and I have a 150 kilowatt facility, and the site could in fact accommodate probably another meg and a half or something, which there's no current intention to do that, but someday we might want to. So adjust whatever I say according to how you feel that might bias my opinion.
Thank you.
I have a technical question, and which is, wouldn't adding, in your example, let's say 5 megawatts to a site that already has 1.5 and is in that metering, wouldn't that require a separate interconnection anyway? So that there's no confusion about which electrons are coming from the net metering site and which electrons are coming from the PPA site. And I don't know whether you know the answer to that, but maybe Peter.
Well, I would just say, regardless of whether I believe that's probably true, regardless of whether that's true or not, the current test would, and the test in our proposal that would apply to the net metering facility, it would include things like, again, to use the example of a road. And so even if you're interconnecting separately, if you were using the same road to get to the 5 as you were to the 150, then you would not, then that would sort of clump the two under the definition that would apply to net metering.
No, I understand that. But what I'm trying to ascertain is there any way how much power is coming from the existing net metering plant as opposed to the new addition could be hard to calculate, hard to figure out.
Oh, no, I mean, they would need separate generation meters regardless, right? There is the infrastructure that would need to be distinct.
Okay.
Simply from an engineering standpoint.
That's the question.
In addition to anything else.
So,
yes.
So there's no way that can become confused. The net metering generation is a thing, and any generation that is added on above the net metering limit would be a separate thing.
Yeah. So if you look at what's in 394, and generally speaking, the concept here is not in fact to allow a large farm to be built up and then the large solar array to be built, and then to have the power sort of like singly metered, and then for the developer to go, well, let's do some net metering here, standard offer, and some PPA. Right. It is actually there are things that are going to need to be distinct. It's trying to minimize the things that need to be distinct to the things that are only strictly necessary for the separate operation of the facilities, not things that they could actually benefit from having the same infrastructure apply to multiple things.
Okay, well, that raises another question. Suppose the developer wants to build a 5.15 site and wants to have part of it in the net metering program, part of it in the PPA, because we probably don't want that to happen. So,
that wouldn't be economical, would it?
I don't know. I mean, net metering is more economical than a market rate, presumably.
For now.
Huh?
For now.
For now, right, right. But so we would want to not encourage that.
I would say that's probably right, but ultimately a policy decision. I think I referenced yesterday, it may have been a question from you, the possibility from a policy standpoint of saying there needs to be some separation in time in order for that like a year or two, whatever needs to pass from the construction of a net metering standard offer in order for this like a new facility to get the benefit of this new single plant definition. I would say it's a policy decision whether that 5.15, like if you were actually building a 150 and a 5 next to each other, but you're only punching in one road and you're doing it at the same time, and the 150 gets the benefit of net metering, is that a good thing or a bad thing? I would, say as a policy decision, it doesn't increase the compensation the 150 would get. It would presumably decrease the cost of building the 150 because the economies of scale. And so that could allow the developer to make more money. That could allow the developer to offer lower costs to that net metering customer. But that certainly isn't, I think, most of what you would see here. It's certainly not the intent. But if you were trying to prevent that, you could put a specific time limited test in the language as well.
Yeah, and I'm just thinking that I'm not making a policy judgment. I'm just thinking about ways to game the system, right?
Of course.
Yep.
So in the scenario that you just laid out, and I may have missed this, are you still trying to consider two separately programmed arrays as a single plant?
The idea would be, well, actually, let me just ask, which scenario? Are you talking about the hypothetical that Representative Campbell brought up, or
No,
the one I put up earlier? The idea would be if you had an existing net metering system and a PPA were built next to it on the same parcel, that those would be considered separate plants, but could share some infrastructure like roads and the poles and wires to get the power from where it's being generated to the utilities distribution system.
So we're getting away from what we're looking at as a single plant definition. We're going beyond that at this point.
It would be defining, it's how you define single plant. Right now, there's a situation where in that hypothetical, you have the net metering next to the PPA. And if any of the PUCs testified to what that test looks like, what the analysis they do looks like, but it considers a number of things, including when, how close the facilities are, when they're constructed, if they share any infrastructure. They have several examples of infrastructure, which I believe includes roads and the poles and wires. And so if the definition is not changed and you have net metering and you put a PPA next to it and that infrastructure is shared, like the road, for example, then that would be considered one plant. And in order to avoid it being considered one plant, you would need to build new infrastructure. Like you heard from Renewable Energy Vermont, this has happened where you've had old facilities with a new PPA added to the site, and poles were taken out, new poles were put in, new wires were put in, a new road was built from a different part of the parcel in order for the second plant to be considered a second plant as opposed to an addition to the first plant. And that's really the fundamental issue that this language is trying to solve, that if you're adding a new plant, you should only have to add the infrastructure that's necessary from an engineering standpoint, not additional infrastructure that is only necessary because of the single plant definition that would add costs to the developer and ultimately to ratepayers. Again, only for projects that are outside of net metering and standard offer with their fixed compensation structures.
Okay, thank you.
Thank you for the question. Thank you very much.
Thanks, Ben. So, yeah, Rep Bailey?
So on that second plan, you still would have a separate metering of what's coming in so that they know how much is coming from each section, right?
Yes. Let me just look at. So the language that we have, and I think this is also in 394, but I don't have the both of is an adjacent parcel shall not be considered. Shall not be considered a single plant if each facility uses separate generators, inverters, and production meters. And so those three things would then become the test for not anything outside net metering and standard offer. And so if you had, one inverter for two plants, that's not two plants, that's one plant. If you had one production meter for two different facilities, that's not two different facilities, that's a single plant. But as long as you are using different generators, which in this case is the solar panels, different inverters, which is what turns it from DC to AC and lets you actually get it on the grid, and different production meters between the two facilities, then it would be two plants. But you wouldn't have to have different roads, different poles and wires.
Right.
Generators, inverter, production meters, and how about interconnection points? Are we contemplating separate plants using a single interconnection point?
The language, I believe the language in 394 does not allow that. Our suggestion would be to allow it, it's just one additional piece from our perspective. You absolutely have to be using different solar panels. You absolutely have to be using different inverters. You absolutely have to be using different generation meters. If you shared any of those things, obviously you would be talking about one plant. If you're connecting to the grid in the same place, from our perspective, and this might not be your perspective, it may not be the PUC's perspective, a different interconnection point is not essential for it to be considered from our understanding, from an engineering standpoint, a separate plant. But that is something obviously that if, as a policy matter, you could say, actually, we want to have as much separation as possible, as as clear a distinction as possible between the plants, so they would need to have separate interconnection points. We included the 3, you could include all 4.
So, sorry, backing up, and then I see, or do you want to go first?
Yeah, well, I just want, on this topic, what's an interconnection point? Is it the physical connection between the production meter and the wires running overhead?
I'm going to let someone with more engineering understanding than I describe that.
I'm sure it would be helpful to me to see the language. Maybe we could take a little break.
Is it first different?
It's based on the Victoria's hand holding up the slides from Rob the other day. It's based on that, but had some additional language to deal with the last issue I raised of not accidentally having an existing plant disqualified from that meter standard offer. So it's very similar to that language, but with a little bit different. And that does not have the construct that I proposed yesterday of having standard offer and net metering and with one definition and everything else with a different definition.
So Ellen doesn't have the language. She can't write it on the fly, right?
I haven't even seen that.
But there's a suggestion, right?
Yeah, I mean,
So-
yeah. Why don't we?
If we want LRT, right?
Yeah. Why don't we? I mean, honestly, I could use like a 5-minute break. Why don't we take a 5-minute break? If anybody needs to go, for example, get coffee or run to the restroom, and then let's come back and maybe we can take a look at the language and help us focus. So, all right.
So we're gonna get the language sent to us.
I want to see if